My name is Hilde Weerts, and together with my co-author Raphaële Xenidis, we're going to discuss our paper, Algorithmic Unfairness through the lens of EU non-discrimination law, or why the law is not a decision tree. So the goal of this paper is really to try and bring the fields of computer science and law in the context of algorithmic fairness together. So we've observed that very often computer science and legal scholars do not really speak the same language. They make use of different types of abstractions, and this can lead to disciplinary misunderstandings. So on the one hand, we have computer scientists who speak of issues of bias, issues of fairness, and then very often you will get the question like, what should be the value of my fairness metric to be compliant with the law? Well, every legal scholar will be able to tell you, well, it really depends, which can be a bit of a dissatisfying answer to a computer scientist who's trying to be compliant with the law. So this raises the question, what types of bias and unfairness the law actually addresses when it prohibits discrimination? Now, when we look at legal scholarship, we, of course, see usage of words like discrimination and equality rather than bias and fairness. And here a question that's often asked is like, oh, can you de-bias an AI system? And here we can see that in some cases, legal scholars can overestimate the capabilities of the technical approaches and also the actual specificity that is required to implement those technical approaches. So this raises the question, what role fairness metrics and algorithms can actually play in establishing and achieving legal compliance? So the idea of this paper was to try to bring those two fields together. And by reading cases of algorithmic unfairness from the perspective of EU non-discrimination law, we're going to see where these notions of fairness and bias overlap or are different from notions of discrimination and equality. And one of the aims that we really had in mind in this paper is to make sure that this is a paper that's readable for both people from the computer science field and legal scholars to further interdisciplinary work into this direction. So now Raphaële is going to tell you what we actually did.
So in the spirit of translating EU non-discrimination law and its application to computer scientists or computer science in general, we analyzed three very influential cases of algorithmic unfairness. The first we chose was the Dutch childcare benefit scandal, where nationality was used in a fraud detection algorithm. So we examined where EU law could apply and also a number of frictions that arise when we try to apply EU non-discrimination law to those cases of unfairness. I'm going to speak only about a select few, but there are many other things that could be said. And we do this from really the perspective of EU law, and we're not going into national law. So in the Dutch childcare benefit scandal, we could apply Article 21 of the Charter, which bans discrimination against members of national minorities, because this applies to public authorities when they are implementing EU law. But one of the issues we see arising is that individuals have a hard time providing sufficient evidence to show prima facie discrimination because they are isolated and do not see the effects of that system globally or from a bird's eye perspective. A second example that we analyzed was the by now really well-known Amazon's hiring algorithm, where an algorithm selected resumes, but in doing so penalized words such as women's chess team. And this has been described as a case of direct discrimination in the literature, but the problem we face here is that the Court of Justice does not treat the distinction between direct and indirect discrimination consistently. So the court could very well look at that case from the indirect discrimination perspective, and this raises a number of difficult questions. One of them is how to show a particular disadvantage. The Court of Justice does not use statistical thresholds here, but follows normative threads, and this can be very difficult to interpret from a computer science perspective. A third system that we analyzed is the gender shades experiments where commercial face recognition systems disproportionately misclassified women with darker skin. And one of the questions this asks about non-discrimination law is whether it applies to disparate product performance or disparate quality of service. And we argue that it could, provided the notion of access is construed in a sufficiently broad manner, but the Court of Justice has actually never been asked this question. Another issue here is, of course, that of intersectional discrimination, where we show that even though the Court of Justice has never explicitly acknowledged intersectional discrimination, and we refer to the Paris case, it implicitly recognized at least combined, if not intersectional discrimination, in other cases where, for example, Oda or Bidi or other cases. So what does that show us is that these cases really show that the law is not a decision tree, and the law is indeterminate. The court does not or hardly relies on statistical evidence, and instead makes judgments based on legal reasoning, looking at the specifics and context of a case, because of course non-discrimination is a polysemous legal instrument that fulfill an array of different functions. So how to respond to this? Next, we examine the problem of emptiness of equality in fairness metrics and in legal reasoning.
So by now, it's clear that indeed, like EU non-discrimination law does not rely on statistics. It doesn't rely as much on specific thresholds. So then what remains? Well, that's actually the normative choices that determine what makes two cases equal or not. So in the next section of our paper, we try to unpack this a bit by looking at the normative underpinnings of both legal and technical interventions. So first, when we look at algorithmic fairness, we can see that different fairness metrics provide different answers to the question of what should be equal. So for example, the well-known metric of demographic parity, which states that the selection rate should be equal between sensitive groups, basically makes a normative decision that perceiving a particular benefit should be independent of sensitive group membership. So on the other hand of the spectrum, we have individual fairness, which states that similar cases should be treated similarly. And here the normative choices are a lot less explicit, because basically all the normative choices are captured in this similarity metric, which is usually assumed to be a given in computer science work on individual fairness. So what we can conclude here is that the normative and empirical assumptions of both fairness metrics, as well as the fairness-aware machine learning algorithms that are used to optimize for them, very often remain implicit and also very underspecified. Now, we might hope that EU non-discrimination law can give us some more guidance. And to some extent it does. So there are some generalizable rules. So for example, the Kresko and Mykola cases clearly show that leveling down is something that's not compliant with EU non-discrimination law. And on the other hand, we have quota-like interventions, which should be limited to flexible quotas, as has been shown in the cases of Kalanki and Marshall. But in other domains, we can see that there's, or not necessarily domains, but in other cases, we see there's not as much of a systematic framework of normative baselines that the court uses. And in some cases, the court is even inconsistent.
So our key message here is that the law is not a decision tree. Non-discrimination law almost never provides explicit constraints for fairness metrics that can be directly translated. So legal compliance is much more about the reasoning and the justification of design choices than actually satisfying a fairness constraint. So what we need to do here is to shift questions about the what to reflections about the why. In other terms, fulfilling the requirements of non-discrimination law demands reflecting explicitly on the normative goal of legal and technical fairness interventions, because not doing so would render the notions of equality and fairness simply tautological. So in shifting questions about the what to reflections about the why, we move away from questions like, what should be the value of my fairness metric, to more difficult yet crucial questions of why a particular distribution of burdens and benefits is right in a given context, and ultimately, who should bear the costs of inequality.